Bankruptcy Law by Andrew Ramsey. What is bankruptcy? Bankruptcy is when an individual, couple, or business cannot meet their financial obligation to their creditors. So they file a petition to be released from some or all of their debt. History of bankruptcy. The origin of bankruptcy goes back to the Roman period, where poverty was everywhere and it was a crime to fall behind on your loan. Debtors could be forced to sell their whole estate to pay back their debt, or in extreme circumstances, an individual could be killed and chopped up into pieces and distributed to all of his creditors. The first real step towards our current bankruptcy law came in the Middle Ages by the Queen of England. In 1705, the British Queen Anne followed Scripture and not the fiscal interest of the country and put an end to all the debtors in prison. This was probably the first bankruptcy law that we really saw until our present ones came about. Bankruptcy laws in America. Bankruptcy laws started out challenging in America with several failed attempts in 1800, 1841, and 1867. All of these had very short lives, mainly due to their differences between political parties and splits in those parties on what should be done. After the appeal of the last one in 1867, there was an uproar for a new one to be passed. In 1889, a group of merchants and manufacturers met under the name the National Convention of Representatives of Commercial Bodies. The president of the convention, a lawyer and a businessman named J. Torrey, drafted a bill that the convention lobbied for throughout the 1890s. The bill allowed both voluntary and involuntary petitions, though wage earners and farmers could not be made involuntary bankruptcy. The bill was primarily directed at liquidation, but did not include a provision for composition. A composition had to be approved by a majority of the creditors in both number and value. In a compromise with the states' rights advocates, the bill declared that the exceptions would be determined by the states. In 1898, they finally saw the Bankruptcy Act of 1898 passed. The Bankruptcy Reform Act of 1978, which replaced the much amended 1898 Bankruptcy Act. The Bankruptcy Reform Act, also known as the Bankruptcy Code or just the Code, maintains the menu of options for debtors embodied in the Chandler Act. It provides Chapter 7, liquidation for business and the individuals, Chapter 11, reorganization, Chapter 13, adjustments of debts for individuals with regular income, and Chapter 12, readjustment for farmers. In 1991, 71% of all cases were Chapter 7, and 27% were Chapter 13. Many of the changes introduced by the code made bankruptcy, especially Chapter 13, more attractive to debtors. Chapter 7 Bankruptcy Claim and how it works. A Chapter 7 case begins with the debtor filing a petition with a bankruptcy court serving the area where the individual lives or where the business debtor is organized or its principal place of business or principal assets. In addition to the petition, the debtor must also file with the court 1. Schedule of assets and liabilities, 2. A schedule of current income and expenditures, 3. A statement of a financial affairs, and finally 4. A schedule of executory contracts and unexpired leases. Debtors must also provide that the assigned case trustee with a copy of tax return or transcripts for the most recent tax year as well as tax returns filed during the case, including tax returns for prior years that had not been filed when the case began. The court must charge a $245 case filing fee, a $75 miscellaneous administrative fee, and a $15 trustee surcharge. Normally, the fees must be paid to the clerk of the court upon filing, but the court's permission, however, individual debtors may pay in installments. Bankruptcy Court Miscellaneous Fee Scheduled Item 8, the number of installments is limited to 4, and the debtor must make the final installment no later than 120 days after filing the petition. For causes shown, the court may extend the time of any installment provided that the last installment is paid no later than 180 days after filing the petition. The debtor may also pay the $75 administrative fee and the $15 trustee fee in installments. If a joint petition is filed, only one filing fee, one administrative fee, and one trustee surcharge are charged. Debtors should be aware that the failure to pay these fees may result in dismissal of the case. If the debtor's income is less than 150% of poverty level as defined in the Bankruptcy Code, and the debtor is unable to pay the Chapter 7 fee in the installments, the court may waive the requirement that the fees be paid. Among the schedules that an individual debtor will file is a schedule of exempt property. The bankruptcy allows an individual debtor to protect some property from the claims of creditors because it is exempt under federal bankruptcy law or under the laws of the debtor's home state. Filing a petition under Chapter 7 automatically stays most collection actions against the debtor or the debtor's property. But filing the petition does not stay certain types of actions listed under 11 U.S.C. 362b, and the stay may be effective only for a short time in some situations. The stay arises by operation of law and requires no judicial action as long as the stay is in effect. Creditors generally may not initiate or continue lawsuits, wage garnishments, or even telephone calls demanding payments. The bankruptcy clerk gives notice of the bankruptcy case to all creditors whose names and addresses are provided by the debtor. Between 21 and 40 days after the petition is filed, the case trustee will hold a meeting of creditors. If the U.S. trustee or bankruptcy administration schedules the meeting at a place that does not have the regular U.S. trustee or bankruptcy administration staffing, the meeting may be held no more than 60 days after the order for relief. During this meeting, the trustee puts the debtor under oath, and both the trustee and creditors may ask questions. The debtor must attend the meeting and answer questions regarding the debtor's financial affairs and property. If a husband and wife have filed a joint petition, they both must attend the creditors' meeting and answer the questions within 10 days of the creditors' meeting. The U.S. trustee will report to the court whether the case should be presumed to be an abuse under the means test described in 11 U.S.C. 704b. Chapter 9 Bankruptcy Case and How It Works. The purpose of Chapter 9 is to provide a financially distressed municipality protection from its creditors while it develops and negotiates a plan for adjustment in its debts. Reorganizing of the debts of a municipality is typically accomplished either by extending the debt maturities, reducing the amount of principal or interest, or refinancing the debt by obtaining a new loan. Although similar to other chapters in some respects, Chapter 9 is significantly different in that there is no provision in the law for liquidation of the assets of the municipality and distributes of the proceeds to creditors. Such a liquidation or dissolution would undoubtedly violate the 10th Amendment of the Constitution and the reservation of the states of sovereignty over the internal affairs. Indeed, due to the severe limitations placed upon the power of bankruptcy court in Chapter 9 cases, the bankruptcy court generally is not as active in management a municipal bankruptcy case as it is in corporate reorganizations under Chapter 11. The function of bankruptcy court in Chapter 9 cases are generally limited to approving the petition, confirming a plan of debt adjustment, and ensuring implementation of the plan. As a practical matter, however, the municipality may consent to have the court exercise jurisdiction in many of the traditional areas of court oversight. In bankruptcy, in order to obtain the protection of court orders and eliminate the need for multiple forums to decide issues, only a municipality may file for relief under Chapter 9. The term municipality is defined in the Bankruptcy Code and is a political subdivision, or public agency or instrumentality of a state. The definition is broad enough to include cities, counties, townships, school districts, and public improvement districts. It also includes revenue producing bodies that provide services which are paid for by users rather than by general taxes such as bridge authorities, highway authorities, and gas authorities. The bankruptcy code requires that the notice be given of the commencement of the case and the order for relief. The bankruptcy rules provide that the clerk or such other persons as the court may direct is to give notice. The notice must also be published at least once a week for 3 successful weeks in at least one newspaper of general circulation published within the district in which the case is commenced, and in such other newspapers having a general circulation among bond dealers and bond holders as the court designates. The court typically enters an order designating who is to give and receive notice by mail and identifying the newspaper in which the additional notice is to be published. The bankruptcy code permits objections to the petition. Typically, objections concern issues like whether negotiations have been conducted in good faith, whether the state has authorized the municipality to file, and whether the petition was filed in good faith. If an objection to the petition is filed, the court must hold a hearing on the objection. The court may dismiss a petition if it determines that the debtor did not file the petition in good faith, or that the petition does not meet the requirements of title. If the petition is not dismissed upon an objection, the bankruptcy code requires the court to order relief, allowing the case to proceed under Chapter 9. Chapter 13 bankruptcy case and how it works. A Chapter 13 bankruptcy is also called a wage earners plan. It enables individuals with regular income to develop a plan to repay all or part of their debts. Under this chapter, debtors propose a repayment plan to make installments to creditors over 3 to 5 years. If the debtor's current monthly income is less than the applicable state's median, the plan will be for 3 years, unless the court approves a longer period for cause. If the debtor's current monthly income is greater than the applicable state median, the plan generally must be for 5 years. In no case may a plan be provided for payments over a period longer than 5 years. During this time, the law forbids creditors from starting or continuing collection efforts. Any individual, even if self-employed or operating an unincorporated business, is eligible for Chapter 13 relief, as long as the individual's unsecured debts are less than $383,175 and secured debts are less than $1,490,525. These amounts are adjusted periodically to reflect changes in the Consumer Price Index. A corporation or partnership may not be a Chapter 13 debtor. An individual cannot file under Chapter 13 or any other chapter if during the preceding 180 days a prior bankruptcy petition was dismissed due to the debtor's willful failure to appear before the court or comply with the orders of the court, or was voluntarily dismissed after creditors sought relief from the bankruptcy court to recover property upon which they hold liens. In addition, no individual may be a debtor under Chapter 13 or any chapter of the Bankruptcy Code unless he or she has within 180 days before filing received credit counseling from an approved credit counseling agency, either in an individual or group briefing. There are exceptions in emergency situations or where the U.S. trustee or bankruptcy administrator has determined that there are insufficient approved agencies to provide the required counseling. If a debt management plan is developed during required credit counseling, it must be filed with the court.